Should justice be based on past behaviors or only on the present crimes? Welcome back to Justice in Focus, the podcast where we break down legal issues in a simple and meaningful way. Today's episode is titled as Pattern or Prejudice. To Daniel's robbery scenario, we will be exploring an important question in the criminal evidence law. Can the court look at someone's past crimes to decide whether they committed the current offense? At first, this sounds unfair. A person should not be convicted just because they have done something wrong before. Obviously, the court is not supposed to say. So, well, did it before, so congratulations. You probably did it again.
Exactly. The law must ensure that every accused person is judged based on the present charge and not just on their reputation.
Okay, well, but at the same time, we cannot ignore something important. What if the past acts are not just similar but almost identical?
Yes, like if the method is so specific that it look like the same person's signature, that is where similar fact evidence becomes very important.
So basically, the issue is whether the past conduct is actually helpful evidence or whether it is just unfairly making Daniel look bad.
So, before we move into scenario, let's first understand what similar fact evidence means. Similar fact evidence refers to evidence of past acts or misconduct of an accused person that are similar to offense currently being tried. These past acts are not part of the present charge, but they may have shown a pattern of behavior or repeated method of committing offenses.
But the law treats this type of evidence very carefully. And honestly, it has to. Otherwise, every accused person with a past record would walk into court already half convicted.
True. The danger is that the court may assume the person is guilty just because they committed similar acts before. That would lead to unfair prejudice rather than fair reasoning based on the facts of the current case.
That is why under Evidence Act 1950, similar fact evidence is generally not admissible unless it falls within specific exception, such as strong, like proving intention, identify, knowledge, or absence of mistake.
And even then, the court must balance whether the probative value of the evidence is stronger than its prejudicial effect on the accused.
The scenario involves Daniel, who is charged with robbery. It is alleged that Daniel used a specific and repeated method, which falls into three categories. First is approaching victims at night. Second is pretending to ask for directions. And third will be then threatening them with a knife. The prosecution wants to introduce the evidence of 3 previous robberies using the same method. So today's central question is the similar fact evidence admissible? Or is it unfairly prejudiced? And the second will be, what factors will the court consider in determining the admissibility? Alright, before diving into the legal arguments, let's meet the panel behind today's discussion. I'm Aishwarya, your host and the chairperson. I'll be guiding the conversation and making sure everything stays structured and hopefully not too chaotic.
I'm Harini, a final year law student and a case analyst. I'll be applying the legal principle to Daniel's situation and looking at whether the evidence actually holds up.
And I'm Shankar, the issue spotter. I will be identifying the key legal questions the court needs to answer basically. What exactly are we arguing about here part?
Hi guys, I'm Rizan, the legal researcher. I will break down the relevant action under the Evidence Act 1950 and explain the case law in a way that doesn't sound like a textbook, hopefully.
And I'm Young Kelvin, the case reviewer. I'll be wrapping things up at the end with the final legal position, so if anyone gets lost halfway, I'll fix it later.
Alright, so perfect. The team is ready. So let's move into the issue, then the rules, followed by the application, and finally the conclusion. In this case, Daniels is charged with robbery involving victims being approached at night, where the prosecution claims that he used a repeated method involving deception and a knife. So, Shankar, let's begin with the main question. What is the legal issue in this case?
The main issue is whether the prosecution can admit evidence of Daniel's 3 previous robberies, which were allegedly committed using a similar method as similar fact evidence under the Evidence Act 1950. The court must decide whether this evidence is admissible for a proper purpose, such as proving identity, intention, or system of conduct, or whether it should be excluded as inadmissible character evidence that is unfairly prejudicial to Daniel. The key legal question is whether the evidence falls under the exceptions in section 11b, 14 and 15 of the Evidence Act 1950, or whether it is being used merely to show criminal propensity.
So basically, the court is asking, is the evidence is useful or is just making Daniel look like a professional robber with a hobby?
Yes, but legally, it must fit with recognized exceptions, not assumptions based on character.
Exactly. That is why section 11b, 14 and 15 of the Evidence Act 1950 are relevant.
The prosecution is relying on the earlier robbery incidents said to involve similar patterns of night approach, deception, and the use of a knife. So, Harini, what exactly is the evidence in the question?
The evidence in question consists 3 previous robbery incidents. In each incident, Daniel allegedly used the same method. He approached victim at night, pretended to ask the direction, and then threatened them with a knife.
So the prosecution say this show a clear pattern or modus operandi.
But the defense says, no, this only shows bad character. So the dispute is really about the purpose of the evidence.
Since this evidence may strongly influence the jury or the judge by showing past conduct similar to the current charge, so it raises fairness concerns in criminal trials. So why is this issue, do you guys think, important?
The legal conflict is whether the evidence is being used for proper legal purpose or an improper one. On the other hand, the prosecution argues that the evidence is relevant to prove identify, intention, or a system of conduct. These are recognized exceptions under the law.
On the other hand, the defense argues that the evidence is simply being used to suggest that Daniel is the kind of person who commits robberies, which is not allowed in law.
Exactly. The law does not allow prosecution to say he looks like the type. There is not legal reasoning. There is just prejudice wearing a suit.
Given that there are 3 similar past robberies and a repeated method involving the deception and the violence, the court must assess similarly the relevance, fairness. But what exactly must the court decide?
The court must decide 3 key things. First, whether the previous robberies are sufficiently similar to the current offense to show a distinctive pattern. Second, whether the evidence is relevant under section 11b, 14 and 15 of the Evidence Act 1950. 13, whether the probative value of the evidence outweighs its prejudicial effect based on the balancing test from the case law. Only if requirements are satisfied will the evidence be admissible.
Since this evidence may strongly influence the jury or the judge by showing past conduct similar to the current charge, so it raises fairness concerns in criminal trials. So why is this issue, do you guys think, important?
This issue is important because it goes directly to the fairness of the criminal trial. Daniel must only be convicted based on the evidence related to the current charge, not assumptions drawn from his past behavior.
However, if the previous acts are highly similar and shows a clear pattern, they may genuinely help to prove, identify, or intention.
So the court must balance fairness to the accused with the need to admit relevant evidence.
So, in simple terms, despite the existence of the similar past robberies involving the same method, the court determined whether this is a legally relevant evidence or unfair character evidence. So, what is the core issue?
The real issue is not whether Daniel has a bad past.
Okay, the issue is whether his past conduct is legally to the present robbery charge.
And whether the similarity is strong enough to justify the admission.
Or whether it should be excluded to prevent unfair prejudice.
So before we go into the similar fact evidence, let's understand the basic rules that controls what evidence can even be admitted in the court.
Under section 101, under section 102 of Evidence Act 1950, the burden of proof lies on the prosecution. This means the prosecution must prove that Daniel committed the offense beyond reasonable doubt.
So Daniel, doesn't it need to prove anything?
Exactly. If no evidence is given, the prosecution fails. This reflects the principles of presumptions of innocence.
So can the court accept any evidence?
No. Under section 5, only fact in issue and relevant facts are admissible.
So even if something looks suspicious, if it's not relevant, it cannot be used.
So what about the statements outside the court?
There is hearsay and it is generally not admissible because the maker is not present for cross-examination.
So saying, someone told me Daniel did it, won't work.
Yes, unless it's false under an exception.
What kind of exceptions?
Under Section 6, also known as res geste, statement made during or immediately after the incident are admissible.
For example, if a victim shouts, "He robbed me with a knife," during the incident, that can be used as the evidence.
But what if Daniel confessed?
And for under Section 34, a confession is not admissible if it is obtained through threat, inducement, or promise.
So the confession must be voluntary.
Because the law wants reliable evidence, not false statements.
So before considering the similar fact evidence, the court must ensure
Okay. So the first point is the prosecution proved the case. Second one is the evidence is relevant. And for the third one is it is not hearsay unless an exception applies. And the last one is any confession is voluntary.
Only after these rules are satisfied can the court move on to the consider similar fact evidence.
So Rizwan, let's enter into the battlefield. The prosecution says Daniel has a pattern. The defense says that's just a prejudice in a disguise. So tell me, under this Malaysian law, can we just drag someone into past crimes because just it sounds familiar?
The general rule is that similar fact evidence is not admissible if it used only to show bad character or criminal tendency. In other words, the prosecution cannot simply argue that because Daniel committed robberies before, he must have committed the current robbery.
Yes, because that would be unfair and highly prejudicial. Basically, once a robber, forever suspect, which the law absolutely rejects.
Correct. However, similar fact evidence may be admitted if they're relevant to be a real issue in the case, such as identify, intention, knowledge, absence of mistake, or system of conduct under the Evidence Act 1950. So the key question is always the purpose for which the evidence is being introduced, not the drama behind it.
So let's be honest. Is the court interested in Daniel's past lifestyle choices or something more serious in deciding admissibility?
Yes, extremely important. If the evidence is used only to attack Daniel's character, it must be excluded.
But if it actually helps prove something legally relevant like identity or intention, then the court can't just ignore it like a irrelevant gossip.
Imagine this. If Daniel always enters into a robbery saying that, "Excuse me, directions," before pulling a knife, is that a coincidence or evidence? Explain Evidence Act under 1950, under Section 1B, if I'm not mistaken.
Section 11B said the facts are relevant if they are inconsistent with or support the existence of the fact in issue, making it more or less probable. So similar fact evidence is maybe admissible where it supports an inference of identify or involvement in the offense, provided there is sufficient similarity and evidence.
So if Daniel's previous method is almost the same as the current robbery, it may make it more probable that he committed the current offense.
But I disagree slightly if the similarity is only general. The court is not impressed by almost similar. It needs a strong similarity, not same vibe, different day.
So Evidence Act 1950, Section 14 basically asks what is accident or Daniel's full-time career plan.
Section 14 allows facts showing intention, knowledge, good faith, or absence of mistake to be relevant. So similar fact evidence can be used to show intention in relation to the specific offense charge and not merely to show general criminal behavior.
In Daniel's case, the prosecution may argue that the repeated method shows intention and planning.
I agree. Basically, it helps show that the act was not random or accidental. Unless Daniel is unlike his accidental robber, and histories are especially with a repeated pattern of description and track.
Now, Evidence Act Section 15 sounds more like if you do it once, maybe coincidence. If you do it 3 times, Daniel, we need to talk. So what does it actually say?
And for Section 15, that states where there is a question whether an act is accidental or intentional, evidence of similar act forming a series is relevant. It is used to show a system or pattern of conduct, also known as modus operandi, where repeated act suggests the offense was intentional rather than accidental.
So if the same method is repeated several times, the court may consider it as a system of conduct.
But I will stress again, repetition alone is not magic. The similarity must be meaningful and distinctive.
So now let's move to a case law. The courts don't just guess, they follow authority. So each case basically stated that this whole, you can't just use a bad character type of rule.
Okay, so the first case is Marking 5 Attorney General for New South Wales, 1894 AC 57, Privy Council. In this case, the accused couple were charged with murdering a baby, which is found buried in their backyard. Evidence of other that in fact found in house they previously occupied was introduced. The Privy Council has said the evidence was admissible because it showed a pattern of conduct and made it unlikely that the death were accidental. The legal principle is that evidence is not admissible just to show bad character, but it is admissible if it proves intent, system, or absence accident.
So marking basically says past actions can speak, but only if they are relevant, not just scandalous.
Exactly not. He looks suspicious, but this evidence actually proves something.
Now, the court doesn't just accept similar, it wants like a wow. That's the same pattern. So, what level of similarity are we talking about in R versus Boardman, if I'm not mistaken, around 1975 AC 421 of the House of Lords? Not surprisingly, still knowing the name.
In R and Broadman 1975 AC 421, the accused was charged with sexual offences involving boys. Evidence from other boys describing similar acts be admitted. The House of Lords held that there must be striking similarity between the acts. The court must also apply a balancing test. The evidence is only admissible if its probative value outweighs its prejudicial effect.
Yes, because otherwise the court risks convicting based on emotion rather than facts. It cannot just make the accused look bad.
Alright, so let's bring it home for the Malaysian context. This is principle applied locally as well, or what is the Malaysian's case authority?
Okay, so we've also got the similarity case, but at Malaysia. The first case, which is Malaysia, is Public Prosecutor V. Muhammad Roslan bin Desa and Anor 2011 for MLG 826 Federal Court. In this case, the accused was charged with murder during a robbery, and the prosecution introduced evidence of a previous robbery with similar features.
In my findings, the federal court held that the evidence was admissible because it showed a similar modus operandi and was relevant to be in the case. However, it must be used only to show bad character, isn't it?
Yes, and the court must ensure that the probative value outweighs the prejudicial effect.
So after all this legal drama around here, what does the court actually check before saying, okay, we allow this evidence and elements that court considers for admissibility?
So, okay, in the court, they will consider relevant under Section 11B. The evidence must relate to a fact in issue. Purpose, it must prove intention or system, not bad character. Striking similarity, the act must be distinctive and highly similar. Probative value versus and prejudicial effect. The probative value must outweigh the prejudice. And the last one is a series or similar acts. Repeat behavior, strengthen a pattern or system.
So overall, similar fact evidence is an exception to the exclusion rule.
So Harini, now let's apply the law to Daniel's situation. Based on the facts, is the similar fact evidence likely to be admissible?
Yes, the evidence is likely to be admissible because 3 previous robberies are highly similar and closely connected to the current offense. This is not the prosecution saying Daniel did robbery before, so he must be guilty again. Instead, they are saying Daniel has a very specific way of doing robbery and the current case look exactly the same. In all the instances, Daniel allegedly approached victim at night, pretended to ask the direction and threatened them with a knife. This consistent pattern suggests a system of conduct rather than the coincidence, making it evidence highly relevant.
I agree, but the key word is similar enough, not just kind of similar. If all robberies in Malaysia are treated as similar fact evidence, then every accused person will basically have a permanent criminal CV in court. But here, the similarity is not generic, it is specific and repeated, which strengthens the argument for admissibility.
So the similarity is not just a robbery behavior.
Exactly. If the only similarity was that all incidents involve robbery, that will not be sufficient because robberies are common offense that can be in many different ways. However, in this case, the combination of timing, deception, and the use of knife in the same sequence creates a distinctive pattern that strengthens the evidential link.
So the prosecution is not saying Daniel robbed me before, so he robbed me again. They are saying this method is so similar that it may identify Daniel.
So, how does the Evidence Act 1950 Section 11B, if I'm not mistaken, apply in this case?
Also, under Section 11B of the Evidence Act 1950, facts are relevant if they make a fact in issue more or less probable. In this case, Daniel's 3 previous robberies are highly relevant because they make it more probable than he is the person who committed the current robbery.
It's like this. If 3 different people randomly rob someone at night, that's not a normal crime behavior. But if a person always appears at night, always asks for direction, and always use the same trick and knife, then the court start thinking this doesn't look like a different criminals. This look like one repeated signature.
It is unlikely that different offenders would independently repeat such a distinctive pattern in the same way.
So the evidence has strong probative value because it links Daniel to the current offense.
But what about the intention under Evidence Act 1950 and under Section 14, if I'm not mistaken?
Section 14 relates to the facts showing intentional knowledge or absence of mistake. In Daniel's case, the repeated conduct shows that the robbery was planned and intentional, not accidental. The consistent behavior of approaching victim at night, using deception, and then threatening them with a knife shows that the Daniel had knowledge and intention to commit the robbery. This supports the prosecution's argument that the Daniel had the required mens rea, meaning criminal intention in the criminal offense.
Basically, Daniel is not doing an accidental robbery. There is no such thing as, oops, I accidentally brought a knife and committed robbery again.
Because honestly, pretending to ask for directions and then using a knife is not exactly something that happens by accident.
And now, how does the Evidence Act 1950 Section 15 comes into the play?
Okay, for the Section 15 applies when there is a question whether an act is accidental or intentional. It allows evidence or similar repeated act to show a system or pattern of conduct, also known as modus operandi.
Here, the 3 previous robberies and the current charge form a clear and consistent series of acts. Daniel's method is not random. It shows a structured pattern targeting victim at night and gaining trust by asking for direction and then using a knife threaten them. At this point, it's not just a robbery. It's just like step-by-step robbery manual.
But remember, in the case of R versus Boardman, the court similarity must be striking. Is this really striking or just like normal repetition?
Under R and V Broadband 1975 EC 421, House of Law evidence is admissible only if there is a striking similarity between the acts. In Daniel's scenario, the combination of nighttime approach, asking for the direction, and knife threat creates a signature style of robbery. This is highly distinctive and threaten the probative value of the evidence.
Exactly. If it were just all our robberies, then it fails. But here, the method is like a signature style, which strengthens admissibility under Boardman.
But to be fair, what is the defense's strongest argument here?
The defense's strongest argument is that the evidence is prejudicial. The court may assume Daniel is a habitual offender and convict him based on his past rather than the present charge. Basically, bad past equals to unfair assumption of guilt. That is a real risk. The court must not fall into the mindset of once a robber, always a robber.
Exactly. That is why the balancing test is important. The court must balance the probative value against the prejudicial effect. The probative value is high because the evidence strongly links Daniel to the offense, proof identify, proof intention, and proof system of conduct. However, the prejudicial effect exists because the court may assume Daniel is guilty simply because of the past robberies.
And this is where the part marking 5 Attorney General for New South Wales 1894 AC 57 becomes relevant. The court confirmed that similar fact evidence is not admissible merely to show bad character, but it is also admissible if proof issue like intention, system, or absence of accident.
And R versus Boardman 1975 AC 421, House of Lords support the idea that the probative value must outweigh the prejudicial effect.
So why might the court still allow the evidence?
The court may allow it because the evidence is not being used merely to show bad character. Instead, it is being used to prove, identify, intention, and a distinctive modus operandi. In this case, the similarity is strong, repeated, and specific. Therefore, the probative value is very high because it is directly helped the court decide whether the Daniel is committed the offense. Although there is some prejudicial effect, it's likely to be outweighed by the strength of the evidence.
Yes, I also agree with your statement. The court must not allow it to become shortcut to conviction.
So what are the key factors will the court consider?
The court will consider degree of similarity, whether the previous acts and current offense share the distinctive and striking features, not just general similarity. Then purpose of evidence, whether the evidence is used to prove, identify, intention, or system, not a bad character. Then number of acts, 3 previous robberies, threaten liability and pattern. Then time of the gap, which is a closer time that makes the evidence more reliable. Then probative value versus prejudicial effect. The truth is value must outweigh unfair prejudice. Then risk of moral prejudice, whether the evidence may lead to confession based on the past acts. Then lastly, distinctive modus operandi, whether the method is unique enough to be treated as a signature.
Young Kevin, after all this legal drama, arguments, and pattern analyses, and so on and forth, what is your final opinion? And Daniel's similar evidence actually admissible, or are we just building a criminal highlight reel for him?
In my view, the similar fact evidence of Daniel's previous robberies is likely to be admissible. This is because the previous incidents are not being introduced to show bad character. Instead, they are relevant to establish key issues in the case, namely identity, intention, and system of conduct. Basically, the prosecution is not saying Daniel is bad, they are saying this robbery looks suspicious, like Daniel's usual routine.
Under sections 11B, 14 and 15 of the Evidence Act 1950, the evidence is relevant because it supports the inference and that the same person committed the offense and that the acts were intentional and systematic.
Okay, like I said before, this position is also supported by Makin 5 Attorney General for New South Wales, R5 Bowman, and the Malaysian case of Public Prosecutor 5 Muhammad Roslan bin Desa and Anor 2011 4 MLG 826 for the record. All of which basically say you cannot convict someone just because they have a bad past. But if the past is doing the exact same thing in the exact same way, the court is allowed to pay attention.
So yes, the law is basically saying past behavior is not relevant unless it's look exactly like the current crime, then suddenly it's become very relevant. Legal logic, sometimes strict, sometimes very observant.
Oh wait, does this mean the court just think, Daniel did it before, so he must have done it again?
No, absolutely not. The court must not use the evidence to conclude that Daniel is guilty simply because he has committed the similar acts before. That would amount to improper propensity reasoning, which is not allowed in law. Instead, the evidence can only be used for a specific legal purpose such as proving identity, intention, or modus operandi. Even if admitted, the court must still evaluate the current charge independently and ensure that Daniel receives a fair trial.
So the court can consider the pattern, but it cannot punish Daniel for his past.
Okay, so what is the final outcome?
The final position is the evidence is likely admissible, but because its probative value outweighs the prejudicial effect. However, it's not admitted to say Daniel is a bad person, so he must be guilty instead of admitted to say this crime looked like it was done in a way that strongly matches Daniel's pattern. So yes, the evidence is coming, but Daniel is still not on trial for his past crimes. Just unfortunately, his past crime decided to show up for the court too.
So that brings us to the end of today's episode of the Justice in Focus. The Daniels case, to conclude, the similar fact evidence may be admitted in criminal trials where there is a clear and distinctive pattern of conduct, but where it is relevant to issues such as identify or intention. However, the court must always ensure that the probative value outweighs any unfair prejudice, so that the accused judged is based on the evidence, not only character. So thank you all, our speakers and listeners. Stay tuned for our next episode. Thank you. This is Aishu signing off.